Hello friends, today's topic is residential status of the person defined under the Income Tax Act. So residential status of the individual, partnership firm, company and HUF we will be studying, and why it is important to determine the residential status of the person. So today's topic is residential status. In the residential status, first we will be covering the residential status of the individual and why the residential determination of the residential status is so important. So why it is important is because based on the residential status of the person, his taxability, the scope of taxability will be determined. So for example, an individual or any person is non-resident in India, then only income sourced in India would be taxable. And vis-a-vis, if the person is resident or an individual or karta of HUF is RoR or that is resident and ordinarily resident, then his global income will be subject to tax in India. On the screen, you can see residential status is defined under section 6. Residential status is to be defined as per section 6. Then point number 1, taxability in India is determined based on residential status of the SSC in the relevant year. That's the point we discussed. Residential status is to be determined every year. So for every previous year, from the period from 1st of April to 31st March, the residential status of each and every person needs to be determined. So in the previous year, for example in 1920, an individual is resident, then for the next previous year, for 2021, it may be possible that that particular individual is non-resident. Third point is individual HUF. For individual HUF, the residency is resident and non-resident. In the resident category, there are two subcategories. One is RNOR, that is resident and not ordinarily resident but not ordinarily resident, and RoR, resident and ordinarily resident. And for firm, AOP, BOI and local authority and company, there are two categories, resident and non-resident. So for the later category, that is firm and company etc., there is no further bifurcation in resident. There is no concept of RNOR or RoR in firm and company. So first we will be considering residential status of an individual. In the case of an individual, the physical stay in India is very important. So the physical stay in the relevant previous year, that is for the period from 1st of April to 31st March, if it is more than 182 days, that is 182 days or more, then a person will be resident in India. Also, there is one more category for person qualifying as resident. Second category is in the relevant previous year, person is physically present in India for 60 days, and for preceding 4 previous year, the person is present in India for 365 days or more. So a person to qualify as resident, there are two categories. First, 182 days or more in the relevant previous year. Then in the relevant previous year, days should be 60 days or more and 365 days or more for preceding 4 previous year. On the screen, first is present in India for 182 days or more. Second, 60 days or more in financial year, that is previous year, and 365 days or more in preceding 4 financial year. So for the 60 days criteria, there are several exceptions. Exceptions meaning if a person is leaving India for the purpose of employment or profession outside India, then he will be, the number of days in that category can be increased to 182 days. So a person who is leaving India for the purpose of employment outside India, the 60 days criteria need not be fulfilled. 60 days criteria will not be applicable. The 182 days criteria will be applicable. Similarly, the Indian citizen leaving India as a crew member of an Indian ship, Indian citizen leaving India as a crew member of an Indian ship, 60 days criteria is not applicable. 182 days criteria is applicable. Second is Indian citizen living in India for the purpose of employment. And third is Indian citizen or person of India origin who has left India for the purpose of employment or profession outside India and who comes on a visit in India. For that person also 60 days criteria won't be applicable. So for example, a person who is living India for the purpose of employment and his number of physical days in India is 150 for the relevant previous year, then 60 days criteria won't be applicable for the purpose of qualifying as resident. 182 days criteria will be applicable, and accordingly he will be qualifying as non-resident, and further there will be implication on the taxability of the individual. So if it is 150 days, a person is qualifying as non-resident, and accordingly the Indian source income will be taxable. And vis-a-vis, if a person is qualifying is 190 days physically present in India, then he will qualify as a resident of India, and based on other criteria, if he qualifies as RoR as well, then his global income will be subject to tax. Global income meaning his income outside India may also will be subject to tax. So in the previous slide we have covered how an individual will qualify as a resident. If one of the two criteria, 182 days or 60 days criteria, is satisfied, then the individual will qualify as a resident. If not, then he will straightforward qualify as non-resident. And suppose if a person is qualifying as resident based on above criteria, based on previous slide criteria, now the further division is as per whether he will qualify as resident and ordinarily resident, or resident but not ordinary resident. So to qualify as RoR, a person should satisfy two conditions. Both the conditions should be satisfied. First is he should be physically present in India for 730 days or more for 7 preceding financial year, 7 preceding previous year, and he should be qualifying as resident in at least 2 of the previous year in the preceding 10 financial year. So two criteria are 7 years, 730 days or more, 10 years should be resident for 2 years. If both the conditions are satisfied, then the person will qualify as RoR. If only one of the condition is satisfied or none of the condition is satisfied, then the person will qualify as RNOR, and there are further implications on the same on the taxability part of the individual. On the screen you can see becomes resident if any one of the above condition is satisfied. Above condition is 182 and 60 days. Becomes non-resident if none of the above condition is satisfied. Then continuing to the residential part, stay in territorial waters is included up to 12 nautical miles. So we have seen the definition of India, what it covers. It covers the territorial waters also, and in the territorial waters it is covered up to 12 nautical miles from the coast of India. So that is even part of India, and any services rendered or any profession setup, business setup within 12 nautical miles will be sourced in India and accordingly will be subject to tax in India. For the purpose of counting the number of days, both the departure date as well as the arrival date will be considered. For example, a person is arriving in India on 1st of April via airplane and is departing from India on 5th of April. So the first and the fifth day both will be included for counting the physical number of days for the purpose of determining the residential status of the individual. Last point is residency does not depend upon the citizenship or place of birth or domicile place. So residential status is strictly based on the person physically present in India. It does not depend whether he is an Indian citizen or a foreign citizen. Now we will be reading the Bare Act of Section 6. Why the reading of Bare Act is very important? Because you will be able to interpret the act as it is, and because the thing is everything is coming from the sections of the act. If you have the habit of reading the section, then you will be able to interpret the section and truly determine what is the intent of the section. So all the relevant sections or all the important sections would be covered in our study material. So first is section 6, which defines or which determines the residential status of the individual and other persons in India. You will be reading word by word, and I will be highlighting the important words. For the purpose of this act, an individual is said to be resident in India in any previous year if he is in India in that year for a period or periods amounting in all to 182 days or more. So this is the first condition for residency. Having within the 4 years preceding the year been in India for a period or periods amounting in all to 365 days or more, is in India for a period or periods amounting in all 60 days or more in that year. So this is the second condition of residency. Continuing to this section, there is an explanation 1. As we have read earlier in the basic concepts, that explanation adds further meaning to the provisions of the act. So in this explanation, what has already been told, it will further expand the scope of the provision of this section. So explanation 1, in case of an individual being a citizen of India, so this will cover the exceptions to the 60 days part. Being a citizen of India who leaves India in any previous year as a member of a crew of an Indian ship as defined under Merchant Shipping Act or for the purposes of employment outside India. So Indian citizen as a crew member leaving India and Indian citizen leaving India for the purpose of employment. The provisions of subclause C was nothing but 60 days clause, shall apply in relation to that year as if the words 60 days occurring therein, the words 182 days have been substituted. B part. So clause B, explanation 1 to subsection 1. This is how we will read the section. So clause B of explanation 1, being a citizen of India or a person of Indian origin within the meaning of explanation to clause E of 115C. So person of Indian origin has been defined under section 115C. Person of Indian origin is nothing but his forefather or parents are staying or were an Indian citizen, and the person of Indian origin may have been shifted outside India henceforth. So he has an Indian connect via Indian citizen. Maybe his father or grandfather maybe are connected with India as an Indian citizen. Who being outside India comes on a visit to India in any previous year. The provisions of subclause C is again 60 days in relation to that year as if the words 60 days occurring therein, the words 182 days has been substituted. So explanation to subsection 1 to section 6. For the purpose of this clause, in the case of an individual being a citizen of India and a member of crew of a foreign bound ship leaving India. So this is a new point that we are covering over here. So first we will read the bare section, bare act, what the section says, and then we will be covering what is the content actually. So again reading, for the purpose of this clause, in the case of an individual being a citizen of India, Indian citizen, as a member of a crew of a foreign bound ship. So foreign bound ship will be, the ship has an Indian connect in a way, it is coming to India on the Indian port and it's carrying the passengers or the livestock and they are delivered over here. The port, the livestock or the goods is delivered on the Indian port, or either it could be that ship is leaving India from the Indian port and is going outside India. So the foreign bound ship leaving India, the period or periods of stay in India shall in respect of such voyage be determined in the manner and subject to such conditions as may be prescribed. So as may be prescribed, there is a rule which is also covered over in here. So rule 126 also covers the taxability of such person, the Indian citizen who are living as a member crew of a foreign bound ship. So the explanation, in this case what happens is, the stay of Indian citizen is determined. Stay of an Indian citizen who is a crew member of a foreign bound ship, he will receive a certain exemption in the number of days when he is on a foreign bound ship for the purpose of employment. So stay of Indian citizen may crew member of foreign bound ship destination being outside India. Explanation 2 to section 6(1). So subsection 1, so explanation 2 subsection 1 to section 6, this is what we have read just now. And there is a CBDT circular which has inserted rule 126 in this regard. So the rule 126 says, if there is, as per the continuous discharge certificate CDC of the Indian citizen, he is on a foreign bound ship for the period from, suppose, for 6 months or 3 months for example, then that particular period will be exempted, will be not counted as a physical day of the Indian citizen in India, and accordingly his residential status is to be determined accordingly. So as per rule 26, date as per continuous discharge certificate while joining and signing off by that individual from the eligible voyage will be exempted. Meaning of CDC: CDC is nothing but, it has been defined under the Merchant Shipping Act, it is nothing but a kind of passport for the crew member. He cannot enter a ship without CDC. So, and the CDC contains the in and out time, in and out stamps of the individual carrying the voyage, of the individual boarding the voyage. So meaning of CDC, which is continuous discharge certificate, this term has the meaning assigned to it in merchant shipping rules made under the Merchant Shipping Act. CDC is a seafarer's identity document. It is mandatory to work on ships. So next is meaning of eligible voyage. What does the eligible voyage means? Voyage undertaken by a ship engaged in the carriage of passenger or freight in international traffic, where the voyage having originated from port in India has as its destination any port outside India, so an Indian connect, and the voyage having originated from any port outside India has as its destination any port in India. So it's the voyage is either coming to an Indian port or it's either going outside from an Indian port. That will be an eligible voyage. An eligible voyage if the seafarer or the Indian citizen as a member crew is going on such a voyage, and so the date visible in the CDC will be excluded for the purpose of counting the physical number of stay of the individual. So we will read the rule 26 over here. It will be discussing whatever we have discussed in the preceding chapters. On the screen, for the purpose of clause 1 of section 6, in the case of an individual being a citizen of India and a member of a crew of a ship, the period of stay in India shall, in respect of eligible voyage, not include the period computed in accordance with subrule 1. So subrule 1 is saying that the period is to be excluded. Now the subrule 2, the period referred to in subrule 1 shall be the period beginning on the date entered into the continuous discharge certificate, in respect of the joining of the ship by the said individual for the eligible voyage, and ending on the date entered in the continuous discharge certificate. So in stamp and out stamp as per continuous discharge certificate in respect of signing off by that individual from the ship in respect of such voyage. So explanation to the rule 126. For the purpose of this rule, CDC has been defined and eligible voyage has been defined. CDC shall have the meaning assigned to it under the Merchant Shipping Rules and the Merchant Shipping Act, and eligible voyage shall mean a voyage undertaken by ship engaged in the carriage of passenger or freight in international traffic, where the voyage having originated from any port in India has its destination on any port outside India, and for the voyage having originated from any port outside India is coming on an Indian port. Now let's discuss an illustration on the CDC concept. I mean, how the number of days will be excluded and how is the concept going in for the purpose of CDC, and if it does come in exam, how to compute the physical number of stay in these cases. So I'm reading the question. Mr. X is an Indian citizen and a member of a crew of Africa bound ship. So Africa bound Indian ship is foreign bound ship engaged in the carriage of passengers in international traffic. So it is satisfying the foreign ship definition or the voyage definition, eligible voyage definition to be precise, departing from Chennai port. So it is originating from India on 1st of June 2019. From the following details for the previous year 1920, determine the residential status of Mr. X for assessment year 2021, assuming that his stay in India in the last 4 previous year preceding 1920 is 401 days, so it's exceeding 365 days, and the last 7 previous year is 751 days, so it's exceeding 730 days. So this two criteria has been given, whether a person would be qualifying as resident, and if he is qualifying as resident, then whether he would be qualifying as ROR or not, based on 7 years criteria. So in the particulars, you can see date entered into the CDC in respect of joining the ship by Mr. X is 1st of June, so in stamp, and date entered into the continuous discharge certificate in respect of signing of the ship is 31st of December. So 1st of June and 31st December. So this is in stamp and out stamp, and the conditions which are required is he should be an Indian citizen, he should be on foreign bound ship, he should be on an eligible voyage. If yes, then the days mentioned as per rule 126, the days mentioned in the CDC will be excluded for determining the physical stay. So for 1920, assuming he was in India for the entire year, so the date as per CDC, that is 1st of June to 31st December, will be excluded. So the number of days that will be counted to determine the physical stay in India will be April, May, entire month the individual was in India, June to 31st he wasn't in India, and Jan, Feb and March he was completely entirely in India. So he was in India for 5 months, which is approximately 150 days, which is less than 182 days. So the number of days is less than 182 days, and the Indian citizen, that if you refer to the exceptions of the 60 days, one of the exception is a Indian citizen living as a crew member of a foreign bound ship, living as a crew member, then the number of days will be counted as 182 days. 60 days criteria won't be applicable to such Indian citizen. So in that case, the number of days will be counted as less than 182 days, and the person will be qualifying as non-resident in India. So the next concept is ANOVA and RoR, which we have already discussed, wherein 7 years 730 days or more, and 10 years 2 years should be resident. More than 2 years, at least for 2 years he should be resident for preceding 10 years. If yes, if both the conditions are satisfied, then a person will qualifying as ROR, else the person will qualify as RNOR. In the screen, RNOR, ROR and RNOR applicable only to individuals and HUF. A person qualifies as ROR if both the conditions are satisfied, resident in at least 2 out of 10 preceding financial years, and 730 days or more in preceding 7 financial years. If none or only one condition is satisfied, then the person will qualifying as RNOR. As per subsection 6 of section 6, a person is said to be not ordinarily resident, RNOR, in India in any previous year if such person is an individual who has been a non-resident in India in 9 out of 10 preceding years. So here it has been written in a negative form. So if we convert it, it's like a person should be resident in at least 2 of the financial years out of 10 preceding financial years. So again, reading, an individual who has been a non-resident in India in 9 out of 10 previous years preceding that year, or has during the 7 previous year preceding that year been in India for a period or periods amounting in all 729 days or less. So if he is 729 days or less, then the criteria is not satisfied and the person will qualify as RNOR. Clause B, a Hindu undivided family whose manager has been a non-resident, whose manager, that is a Karta, has been a non-resident in India in 9 out of 10 previous years preceding that year, or has during the 7 preceding years less than 729 days. So for the Karta of the HUF as well, if Karta of the HUF is qualifying as RNOR, same as individual, then the HUF would also be RNOR, and accordingly the taxability will be changed. So coming to the illustration part for the residential status of the individual, first is Mr. X, a foreign citizen, visits India for 100 days in every financial year since past 10 financial years. Find out the residential status for assessment year 2021, that is previous year 1920. So foreign citizen visiting India for 100 days. So 1920 residential status, if you see, it is 100 days. So 182 days criteria is not getting satisfied over here. 60 days criteria is yes, and 365 days criteria would get satisfied because 100 days for past 4 years is 100 into 4, so it's exceeding 365 days, that is 400 days. So 60 days criteria is getting satisfied over here. And to add on the exceptions to the rule 60 days, here it won't be applicable to the foreign citizen. All the exceptions are applicable to an Indian citizen who is either visiting for the purpose of employment outside India, or as a member crew of an Indian ship, or who is visiting again to India, who is employed outside India. So it is, the exceptions are only applicable to Indian citizen, it's not applicable to foreign citizen. So the person till now is termed as resident. Now whether he would be termed as RNOR or ROR needs to be determined. So the two criteria being 730 days, whether it is getting satisfied or not, in this case it won't get satisfied because 100 days for past 7 financial years is 100 into 7, which is 700 days only, which is less than 730 days. So, and the second criteria, it's irrelevant in this case because both the conditions are to be satisfied, and over here 730 days out of the preceding 7 years criteria is not getting satisfied. Accordingly, the person would be termed in this case as RNOR. Second illustration, Mr. A, a foreign citizen, comes to India for the first time during the financial year, during the previous year 15-16. So he has no past record before 15-16 of visiting India. 15-16, 16-17, 17-18, 18-19 and 19-20 he was in India for 55, 60, 90, 150 and 70 days. So for 1920 financial year he was in India for 70 days, which is less than 182 days. So this is not getting satisfied. And for 60 days criteria it is getting satisfied. What about 365 days over here? 365 days, we need to add up 55, 60, 90 and 150. 55 plus 60 plus 90 plus 150, it is 355 days. 355 days, it is less than 365 days. So this criteria, even 60 days criteria, is not getting satisfied, and the exception again to a foreign citizen, it won't be applicable. Accordingly, since both the conditions are not getting satisfied over here, the person will be deemed to be non-resident over here. Now, after residential status of an individual, we come to the residential status of HUF. The HUF will be resident in India based on the control and management of its affairs. So, if the control and management are wholly or partly in India, then the HUF is resident. If the control and management is completely outside India, then the HUF is treated as non-resident. Now, what is control and management? On the screen, we will read the definition of the control and management. The expression control and management referred to under section 6 refers to the central control and management and not to carrying on day-to-day business by servants, employees or agents. So the services which are provided by employees, servants and agents, the place from where it is provided is not relevant in this case. Second point, the business may be done from outside India. The business may be done from outside India and yet its control and management may be wholly within India. Therefore, control and management of a business is said to be situated where the head and brain of the adventure is situated, meaning head and brain meaning where the effective decisions, where the controlling decisions or directing decisions are taken is the relevant place for determining the control and management. Third point, the place of control may be different from usual place of running the business and sometimes even the registered office of the SSC. This is because the control and management of a business need not necessarily be done from the place of business or from the registered office. So in this case, the principal office of the company, the principal office of the HUF or the registered office of the HUF may not be relevant for determining the control and management of the affairs of the HUF. Fourth point, but control and management do imply the functioning of the controlling and the directing power. The controlling and the directive power are relevant for determining the residency of the HUF at a particular place with some degree of permanence. So effectively, HUF will be resident in India if its control and management is wholly or partly in India, and when the HUF is considered as resident, for HUF to be determined as RoR or RNOR, the residency of the Karta is important here. So if the HUF is resident, now we go to the residency of Karta, in which case if Karta of the HUF satisfies the RoR conditions, that is 730 days and 2 years residency condition for preceding 10 years, then if Karta is RoR, HUF is RoR. If Karta is RNOR, HUF is RNOR. On the screen you can see for RNOR and RoR, conditions are similar as individuals and it is same for Karta as well. So residency of Karta is residency of HUF for determining RNOR and RoR. Let's read section 6 subsection 2. Hindu or divided family, HUF, firm or other association of person is said to be resident in India in any previous year in every case except where during that year the control and the management CNM of its affairs of the affairs of HUF firm AOP is situated wholly outside India. So it will be considered as resident in every case except for the condition that the control and management is situated wholly outside India. Subsection 3 states the resident of the company. Company will be resident in India if it's an Indian company. Indian company meaning, as per the definition of the Indian company, company is to be registered with the Companies Act 2013 or 1956 and the registered place or the principal office is in India. So company is said to be resident in India if in any previous year it's an Indian company or POM place of effective management. Place of effective management in that year is in India. Place of effective management poem is relevant in case of foreign company. Is relevant in case of foreign company. Explanation to subsection 3 of section 6. For the purpose of this clause, place of effective management means the meaning it has been defined through an explanation, means a place where key management commercial decision, key management and commercial decision, managerial decisions and commercial decisions that are necessary for the conduct of business of the entity as a whole are in substance made. So where the managerial decisions are made, where the commercial decisions are made, is the place of effective management of the foreign company in India, foreign company. And if it is in India, then the foreign company will be considered as resident in India as per subsection 3 of section 6. Subsection 4 and 5. So subsection 4, every other person is said to be a resident, so is a residual category. Subsection 2 was relevant for firm, AOP and HUF. Subsection 1 is relevant for individual. Subsection 3 is relevant for company, and every other person not covered above is said to be resident in India in any previous year in every case, except where during that year the control and management CNM of his affairs is situated wholly outside India. So it's similar to HUF firm and AOP, wherein control and management is in India, is wholly or partly in India, then it's a resident. If control and management is wholly outside India, then it will be considered as non-resident as per subsection 4 to section 6. Subsection 5, if a person is resident in India, if a person is resident in India in a previous year relevant to the assessment year in respect of any source of income, he shall be deemed to be resident in India in the previous year relevant to the assessment year in respect of each of his other sources of income. So, meaning a person who is resident for one source of income will be deemed to be resident for other source of income as well. So, for example, income from salary, income from house property, income from business and profession, if the residential status is RoR, it will be deemed to be RoR for all the heads of the income. Now, illustration for determining residential status of an HUF, The business of a HUF is transacted from outside India, and all the policy decisions are taken there, meaning it is outside India. So we can conclude till here that CNM, control and management of affairs of HUF, are outside India. SSC, the Karta of the HUF, who was born in India, Indian citizen, visits India during 1920 after 15 years. So no background of past years for 10 years, 7 years. He comes to India on 1st of April and leaves on December 2019. So over here he was in India for 8 months up till 30th of November effectively, and 8 into 3, almost for 245 days, 250 days he was in India for the previous year 1920, and no previous year background up till 15 years. Determine the residential status of SSC and HUF. So for HUF, if we see, transaction and policy decisions are taken outside India, so HUF will be non-resident as control and management is outside India, is wholly outside India. So effectively, if we are determining residential status of HUF, we need not go any further, because if it would have been resident, then we will have to see residential status of the SSC over here. But since HUF is qualifying as non-resident upfront, then it won't be qualified as RNOR or ROR, and we need not see the residential status of the Karta of the HUF. But the question over says here the residential status of SSC also needs to be determined. So for SSC, the number of stay of 182 days is getting satisfied as number of days is 245 days. Okay, and the past year he wasn't in India for 15 years, then he will be qualifying as RNOR. So residential status of the SSC is RNOR and residential status of HUF is non-resident. Now, residential status of the firm, local authorities, AOP and AJP, we have already covered this under subsection 3 or subsection 2 and subsection 4. So, control and management, if wholly or partly in India, then resident, wholly and partly outside India, then non-resident. Residential status of company, it should be an Indian company, or POEM should be in India. That is what has been stated over here along with the definition. So, if it's an Indian company, it would be resident. If POM is in India of the foreign company, then it would be treated as a resident of India. So this was the end of the topic, in which, and I will quickly summarize what we have learned over here. So residential status, we have learned residential status of individual, firm, company and other person of which are defined in the income tax act. Why the residential status is important to determine? It's because the scope of total income is determined based on the residential status of the individual, and for counting the physical number of stay for the individual and HUF, both the date of departure and date of arrival, it's to be considered. Territorial waters up to 12 nautical miles, it's to be considered for determining the physical stay in India. And residential status is to be determined each and every year for individuals. The category is like resident and non-resident, and the resident category is further divided into RNOR and ROR. For other category other than individual and Karta of HUF, the criteria is only to resident and non-resident based on control and management, or based on POEM for the companies, for the foreign company. Residential status of individual is 182 days or more, first criteria. Second criteria is 60 days or more and 365 days or more for preceding 4 years. If one of the condition is satisfied, then person, individual, will be treated as resident. For resident to be qualifying as RNOR or ROR, the person has to satisfy 2 conditions, which is cumulative. Both the conditions are needs to be satisfied. 730 days or more for preceding 7 years, and 2 years should be resident in the preceding 10 years. If both the conditions are satisfied, then ROR, and accordingly the global income would be taxable of the concerned person. 60 days rule has 3 exceptions, in which is applicable to only Indian citizen living outside India for the purpose of employment. 60 days rule won't be applicable, only 182 days rule will be applicable. An Indian citizen as a crew member of a foreign ship, of an Indian ship, would be 60 days would be applicable as a 182 days rule. Then Indian citizen who is coming to India for the purpose of visit, 60 days rule won't be applicable to such individuals. Then we have read an Indian citizen as a crew member who is going on a foreign bound ship, in which case the stamp in and stamp out mentioned under CDC, continuous discharge certificate, will not be counted as physical stay in India, and accordingly that will not be considered for the residential status of that particular individual, which is exempted as per rule 126 of the income tax rules. Then we have learned several illustrations. Then we have learned residential status of HUF, in which control and management of the affairs of the HUF is important. Similarly, control and management concept is coming for firm, local authorities, AOP, artificial judicial person as well, in which CNM, if is wholly and partly in India, wholly or partly in India, then the person is said to be resident. If CNM is completely outside India, then the person is treated as non-resident. And for companies, Indian company and POM is the factor to be considered. Thank you.